series. And today we're going to talk about fence law. More specifically, we're going to really focus on Texas fence law. And so I do want to give you a little bit of a heads up that some of the general principles may be applicable in other states, but the specifics of the law are definitely geared toward Texas. So just a little heads up on that if you might own property elsewhere. And so like Pete said, my name is Tiffany Lashmet. I'm an Extension Ag Law Specialist with Texas A&M AgriLife Extension. I'm based up in Amarillo in the Panhandle, but I have statewide responsibilities. So I do extension programming, outreach, educational work kind of around the state. So really excited to be here. When I speak, I have to give a disclaimer. It basically says I'm a lawyer, but I'm not your lawyer. So today I'm certainly happy to provide you with some general information. I'm certainly happy to answer questions to the extent I can in the chat box, but I can't give anyone specific legal advice. To the extent you need that sort of advice, you'll need to contact your own attorney. And so with that, let's get started. We're going to sort of look at a couple of basic fence law concepts first, and then we're going to drill down into a few concepts in more detail. And the first thing, anytime you're dealing with a question about fence law, is you've got to figure out if you're in an area that's open range or closed range. Because for a lot of questions, the answer to that is going to help you determine the answer to whatever question you're dealing with. And everybody's probably pretty familiar with this. Open range, that's an area where the landowner has no duty to fence their livestock in or prevent them from running at large. Instead, the duty would be on the neighboring landowner to fence the animals out. So sometimes you'll hear open range referred to as a fence out area. In general, in an open range area, the livestock owner is not liable for injury or damages caused by the loose livestock. There are a few, minor exceptions to this, but generally you're not liable because you don't have an obligation to fence them in, right? So, and we'll look at some cases on this in detail in a few minutes, but in general, if you have an animal that gets hit on a roadway, if it's an open range area, the owner is not liable. Again, because they just don't have a responsibility to fence those animals in. So there are a couple of exceptions to this, and this essentially would mean that you may be required to fence your animals even if you're in an open range area. One of those is if the neighbor, right, if your neighbor has built a sufficient fence, and there's a definition of what that means in the Texas Agriculture Code. It's pretty low bar. I think for a barbed wire fence, it only has to be a 3-strand fence. But essentially, if your neighbor builds a sufficient fence to try to fence your animals out, but they keep getting in, you can be liable for that. And so the way I think about that is the law requires the neighbor to build a fence, not Fort Knox, right? And so do keep in mind if your neighbor builds a fence, but your animals keep getting in, even in an open range area, you may be liable there. You can also be liable in an open range area if you intentionally drive your animals onto the property of another, and you can be liable for any damages if you have knowledge of diseased, breachy, or otherwise vicious livestock. So again, general rule, open range area, no duty on the animal owner, no liability for loose livestock, subject to those kind of handful of exceptions. The flip side of that is a closed range area, and that's just an area where the animal owner does have an obligation to fence their livestock and to prevent them from running at large. All right, so sometimes you'll hear this called a fence-in area, again, because the obligation is on the landowner to fence those animals in. So, with all that background, what is Texas? Well, the general rule, our starting point, is that Texas is an open range state, okay? However, there are a couple of major exceptions that actually change that and make most of the state of Texas be closed range. All right, so here's kind of how this works. The starting place for any analysis in Texas is that Texas is an open range state, unless there has been a law passed that changes some portion of the state from open range to closed range. All right, and those laws come about in two ways. The first one is a state statute that says all U.S. and state highways anywhere in Texas are closed range. All right, and specifically what the statute says is that an animal owner cannot knowingly permit animals to run at large on state or U.S. highways. All right, now, for our purposes here, a state or a U.S. highway is going to be, does not include farm to market roads. So that's going to be like, you know, I-35, I-40, Highway 6, Highway 287. Okay, it doesn't include farm to market roads, does not. All right, so the answer then is if you're on a state or a U.S. highway and you've got an animal that gets out, we know that that's going to be closed range. And what a court would look at to decide liability is, did the landowner knowingly permit the animals to run at large? If you look at some court definitions of what knowingly permit means, they say that the owner has to act deliberately, consciously, or have or show an awareness or understanding. I don't find that all that helpful on a practical level because it's just these words, right? So we're going to look at some case examples here in a minute that I think will help make that a little bit more clear. All right? The other type of law that can change parts of the state from open to closed range are local stock laws. And so state statute allows a county to hold a local election and vote on whether all or some part of the county should change from open range to closed range. If that election is held and it passes, then what those local stock laws will say is that owners may not permit livestock to run at large. So you'll see it's still closed range, but that standard's a tick different than the state and U.S. highway standard. The highway standard says knowingly permit, whereas the local stock law standard just says permit. And so what permit is defined as is consenting expressly or formally, giving leave, or knowing conduct. Again, I don't know, that's not super helpful for a landowner, right? I mean, do you have to give the bull an invitation to leave the property? I don't know. We're going to look at some cases. I think that those are going to give you some better examples. What I will say is that on the difference between those two, the knowingly permit standard and the permit standard, it's clear that the knowingly permit standard is more landowner friendly. In other words, it's harder for an injured plaintiff to prove you knowingly permitted them to run at large than you permitted them to run at large. And again, we'll look at some cases here in just a minute. So hopefully after the last slide, you're asking yourself, well, I wonder if my county is open range or closed range. And that's a good question, and one that you really need to know if you're a livestock owner. And so how do I figure out the answer to that? Well, I would start by talking to some people. That's easier than going digging for the results of that local stock law election, because a lot of those elections were held back in the early 1900s, and the results are in the county commissioner court records. A lot of them were like handwritten in cursive handwriting. So where I would start is I would talk to your county extension agent, your county sheriff, county attorney, county judge, or county clerk. Hopefully they've looked at this before. They know the answer and can help give you the information without anybody having to go dig back into commissioner court minutes from 1912 or whatever. So that's what I would do. I would start there when you want to look at these. And when you're looking at them, there are a few things you need to take into consideration. The first is you need to pay attention to what part of the county the stock law applies to. Some of them will be the whole county, right? It'll say Wilson County, for example. That stock law says that the entire county is closed range. Some of them may have done it by precinct. So an example of that I know is Lipscomb County. It was like precinct 1, they voted one way, and precinct 2 voted different. And so it's going to depend where you are in the county. So look at how much of the county it applies to. Also look and see what animals it applies to. So you may have situations, and a lot of times you will, where there might be one local stock law passed for cattle and a separate one passed that deals with horses, donkeys, sheep, goats, and pigs, for example. All right, so make sure when you're looking at these, you kind of drill down to that level of detail. Now, I'm going to cheat for you a little bit if you happen to be in one of these 22 counties. And I can tell you that, at least for cattle, these counties that are listed are open range. And that's because there's a state statute that says these counties are not allowed to be closed range for cattle. So if you're in one of these counties, take a look. We know for sure you are open range for cattle. All right. So with that, what I'd like to do is jump into some example cases, because I think this will help clarify the different standards, how courts would evaluate this, what you would want to look at factually to decide whether you were in an open range or a closed range area and whether or not you might be liable. Okay, so here we go. And this is going to be interactive. Pete's going to help me here in a minute. We're going to do some little voting, a poll, if you will. So get ready with your mouse to click on the poll here in just a minute. The first case we're going to look at came out of the Texas Supreme Court, and it's a case called Gibbs versus Jackson. And in that case, a driver hit a horse named Tiny, that is ironic, on a farm-to-market road in a county with no stock law. The driver sued the horse owner for negligence and said that the fences were in disrepair and the horse had been out before. So where we want to start, the first thing we want to look at in any fence law case, right, is are we in an open range area or a closed range area? Right, so we know that the general rule is open range, so we have to ask, do one of those laws apply? So is this on a state or a U.S. highway? No, it's a farm to market road, right? So that one doesn't change it to closed range. And then does the county have a stock law? No, which means, okay, we're in an open range area. And remember, that means that the owner of the horse has no legal obligation to fence the horse in. All right, so what is the verdict? Pete, do we have our poll? Uh-oh, it's not popping up. There it is. What do we think the verdict is here? Is the horse owner liable or not liable in Gibbs versus Jackson? We'll give you guys just a second to vote. Okay, it looks like we've got about all the votes in. And so it looks like 45 of you were right. The landowner is not liable in this case. And again, the reason here is there's just no legal duty to fence an animal in if you're in an open range area. And so even if the facts said that the landowner had no fence at all, he still wouldn't have been liable because he's not obligated to have a fence. All right. Now, if this case had happened in a closed range area, very different analysis, and I think the landowner would have been liable. Okay, so there's our first case. Let's look at our next one. In this case called Evans versus Hendricks, cattle were hit by a truck on a state highway in an open range county. The cattle were kept on the back portion of the pasture away from the road. The gate was both locked and chained, and the landowner never knew that his cattle were out. All right, so let's start again. What's our applicable standard here? Are we open range or closed range? Okay, we know we're in an open range county, but we're on a state highway. And remember, that means it's closed range. And the question for the court is going to be, is the cattle owner, okay, did the owner of the cattle act with knowledge? In other words, did he knowingly permit those cattle to run at large? Right? If he did, he's going to be liable. If he did not, he won't be liable. Okay? So let's look and see what we think the verdict is. Pete, can we get our next poll up, please? Do we think that the owner of the cattle is liable? Yes or no? Oh, and Dale, you brought up a good question. Dale says, I'm using the term landowner and animal owner interchangeably. Is there a distinction? That's me being sloppy. When we're looking at the cases, all of the lawsuits were against the animal owner. And I actually think that in all of these cases, the animal owner was the landowner, and that's why I'm being sloppy. If you were in a situation where there was leased land, the general rule is that a landowner is not liable if there's a lease in place. There can be some minor exceptions, but generally it would be the animal owner who is liable. So again, in the case examples, it was the same person, but there could be that distinction if there was a lease in place. Okay, so here we've got about 3/4 of you say that the landowner was not liable, and that's accurate. All right, so the court here agreed. They dismissed the case. Looking at these facts, the court said, we don't think the landowner knowingly permitted them to run at large. Okay, so again, what's important here is keep in mind, even if you're in a closed range area, if your animals get out and get hit on the road, you're not automatically liable. Okay, you're liable only if you acted, in this case, under that knowingly permit standard. Okay, so let's look at another case. We got 2 more to go. This one was called Weaver versus Brink. In this case, cattle were hit on I-45 in a county with no stock law. The cattle had previously escaped 6 times in 15 years. The owner knew that the fences failed during hard rains and testified that he knew that there was a good chance of failure that day. He did not go check on the fences. He was told the night before the accident that the cattle were out, but he did not go put them in. All right, so again, what's our standard? First question, is it open range or closed range? Okay, we got closed range, right? Because we're on a U.S. highway, I-45. And so again, we've got that knowingly permit standard. So what's our verdict? Pete, will you hit the poll for us? Do we think that the landowner here knowingly permitted those animals to run at large? Okay, it looks like we've got our first unanimous or almost unanimous poll result here, and everybody seems to think that in this scenario, the landowner would be liable. That's exactly what the court found. And again, when you look at these facts, the court said this was enough to say he knowingly permitted it. And if you think back to those, definitions we had that talked about deliberate or conscious or, this kind of consent or awareness to, you see how these facts are different than the last case, right? And it's this kind of factual analysis that courts really look into. The last case I want to look at is Rodriguez versus Sandhill Cattle Company. In this case, a driver hit some cattle on a farm to market road in a county with a stock law. 5-weight cattle, so that means 500-pound cattle, were in a pasture with a 1-strand electric fence. The cattle were hot wire broke. They had never been out before. All right, so what do we think? What's our standard? Are we open range or closed range? We're closed range, right? Because of the stock law. And so the standard here is permit. Did the landowner or the animal owner permit these cattle to run at large? Let's vote on this one, Pete. What do we think? So if he permitted them to run at large, he is liable. If he did not permit them to run at large, he is not liable. Let's vote on this one. And then Bob, I'm going to answer your question as soon as we finish this slide. Okay, looks like most of the votes are in, and the vast majority of you think the landowner is not liable, and you are accurate. The court here said the landowner did not permit the livestock to run at large and dismissed the case. I will say this case happened in the Panhandle, and just for context, a lot of us have cattle behind electric fences in the panhandle on wheat pasture. And so pretty standard practice. And the court said, you know, there was no evidence from the injured party that that electric fence was any less effective than a like a barbed wire fence, for example. Had there been that type of evidence, maybe it's different, but there just wasn't in this case. One question that we've got, somebody asked, what does it mean to be hot wire broke? I'm sorry about that. That's sort of the term that we use here. It just basically means they were used to the hot wire fence. There weren't issues with them getting out. So you'll sometimes hear people call that hot wire broke. In other words, they've been behind that fence. They have not had issues. They sort of, you know, stay behind the electric fence. Sorry for that. I see how that's confusing. They thought that it meant the hot wire fence broke, not that the cattle were hot wire broke. That is confusing. I may reword that going here forward. Okay, so that's our example cases. I hope that helps spell out how that liability works. We've had two questions on leases, so let me address that just really briefly. In order for, Bob's asked a question that asked if a landowner has to have a written lease in order to not be liable. No, okay, there's no requirement that a landowner has a written lease to sort of, you know, shirk liability in that scenario. But I will tell you, I'm a fan of written leases and think everybody should have them, okay? And so for a couple of reasons, from a liability standpoint, if you've got a good written lease, it should have a provision in there that says the landowner is not liable for the acts of the tenant and vice versa. And it should have what's called an indemnification clause that says the tenant's going to hold the landowner liable in the event there is a lawsuit or some sort of claim. That can be really important to have. It's just useful. Doesn't mean you have to have it, but it's just kind of extra evidence that can be really helpful. So I would really recommend having a written lease. And I said before, let me just repeat it again. In general, if you are a landowner and you've leased your land out for grazing to someone, the general rule is you are not liable for anything that happens during the term of that lease. There are a few minor exceptions, but in general, no liability for a landowner. Now, I want you to keep this in mind. Just because I say no liability, that doesn't mean no lawsuit, right? And I'll just tell you, if there's some sort of accident that happens with the landowner, if there's some accident that happens with a landowner and a tenant, right? Even though the cases are pretty clear that the landowner is generally not liable, I'll tell you that the landowner oftentimes finds themselves the defendant of a lawsuit. And you've got to, you know, file motions and that sort of thing to get dismissed out of the lawsuit. And so keep that in mind. And that is why I would always make sure as a landowner I had liability insurance. All right? Because one benefit of having good liability insurance is it provides you a defense in the event there's something that happens and you get sued. So I would certainly look into that and make sure you've got it, whether you're leasing or not. Okay, Ryan asked a question. Can the landowner put the fence responsibility on the tenant and avoid responsibility? Yes. In a lease, a landowner certainly could require that all maintenance and repair of fences is the responsibility of the tenant. That's another good piece of evidence that can be used if something like this comes up. Even without that clause, the odds are the landowner wouldn't be responsible unless the landowner had said they would maintain the fences. So again, written lease, helpful, helpful, helpful. Please get those. On that note, as far as leases go, if you are someone who does have land that you're leasing out for grazing, we've got a couple of resources that might be helpful for you. I'm going to put them in the chat box here right now quickly. The first one's a handbook we've got. It's called the Rancher's Agriculture Leasing Handbook. And what you'll find in there is all kinds of information about leases, including a checklist for writing a grazing, hunting, or livestock lease that may be helpful, and some sample language. So there's a link to that PDF right there in the chat box. The other link I'm going to give you is for our online Ranchers Leasing Workshop course. It's about a 3-hour course that we teach all about agricultural leases, again, really focusing on grazing and hunting leases primarily. So there's links to that if you're interested. There's just some more info there. Okay, with that, let's move on because I'm going to go over time and Pete's going to have to fire me. I want to mention an interesting case that recently came out of the Texas Supreme Court dealing with this issue. And the question sort of was, what does the law say if we're in a closed range county that, right? And so for the county, the law says you can't permit your animals to run at large. And then we're also on a state or U.S. highway. And that rule says you can't knowingly permit the animals to run at large. We know it's closed range, but which standard applies, right? Is it a permit standard or a knowingly permit standard? That was the question that came up in Garcia versus Prusky. And I'll tell you, there's a lot of counties where this could be an issue. And what happened in that case, it was Wilson County. They have a stock law that was passed, I think, in 2010-ish. And a vehicle hit a bull on a state highway in Wilson County. The facts were that the owner had only had one cow out 8 years ago. The gate was latched, so he fastened the latch, and there was a padlock there, but he didn't lock it. He left that open because later that day a contractor was going to come onto the property. The bull got out, broke the latch, and got out onto the state highway. A driver hit the bull, and the driver filed a lawsuit claiming that the owner both permit and knowingly permitted that bull to run at large. The Texas Supreme Court, hearing this, sided with the bull owner and said that it was only that knowingly permit standard that applied. Let me explain to you why that matters, okay? In this case, with these facts, the trial court said, if the standard is knowingly permit, we do not think the plaintiff can prove that, and we're going to dismiss the case. But the trial court then said, if the standard is permit, we think that there's at least enough evidence here for there to be a question for a jury, and we're going to let the case go forward. Okay, and so this was the first time that the Texas Supreme Court had answered this question. And again, if you're in that scenario where I guess I would kind of call it double closed range, right? It's only that higher standard that permits. And so from the landowner perspective, this was a positive outcome in that case. Okay, next up, let's chat about the estray law. So this deals with animals that get out, right, or animals that are on the property of another. You can call them estrays if you want. If stray livestock are on your property, you don't get to sell them or keep them. I like to tell people that the finders keepers rule doesn't apply for cattle. That only works on the playground. All right, and so the law that does apply is the Texas Agriculture Code Chapter 142. And that's an entire procedure for what to do if there's an estray situation. If you look at that statute, what it says is that the landowner needs to contact the sheriff as soon as reasonably practical to report that these animals are on their property or that they're out, right? If they were out on a road, you could report them as well. If no owner is found within 5 days, the sheriff will impound the animals. I'll tell you, I think that depends on your sheriff if they wait to 5 days or if they go ahead and get them out of there. If they do find the owner, the sheriff can impose a redemption payment, and that money will go to help reimburse expenses of the sheriff and the landowner that found the animals. If they can't find the animal owner, the sheriff's got to post a notice and conduct a diligent search. So sometimes you'll see in the paper or on like the bulletin board at the courthouse, 5 black calves found on Farm to Market 1270 or whatever. That's why they do that. They've got to do this diligent search for the owner. If the owner is not found, the sheriff can sell the animal at public auction. So that's kind of how that works. Again, finders keepers is never a thing. The law says that that's what your options are. Now, a couple things here. One of them is before you call the sheriff, if you know whose animals they are, try to give them a call. I know that sometimes if you've got neighbors that are jerks and this is a recurring thing, there's no choice but to call. And if you don't know whose they are, you may need to call. But if you can avoid, having to get the sheriff out there, it's probably better for neighbor relations if you can do that. So I see a comment here, and I've heard this in other counties as well. Sometimes the sheriff won't come and get them. I'm not sure what the thing to do there is, because the statute's very clear that that's the obligation of the sheriff. And so that may be a scenario where you need to, maybe we need to do some education for sheriffs. Maybe we need to contact supervisors or something like that, because the statute's very clear that that is the duty of the sheriff. And without them doing that, I'm really not sure legally what a landowner can or should do, because I think there's some legal implications of doing anything else. On this note, there was an interesting Attorney General's opinion that came out earlier this year I want to mention to you guys. So it was from Presidio County, and that's out far west Texas, and Presidio County is open range by statute for cattle. So they're one of those 22 counties that we mentioned that cannot be closed range. So for cattle, they are open range. There was a little bit of a dispute out there between the sheriff and the county attorney, who disagreed on whether the estray law applies in that county. The sheriff said, look, the estray law gives us the responsibility of dealing with stray livestock. We have to enforce it. The county attorney says, hey, the estray law doesn't apply in an open range county. Okay, and so the question we've got here is essentially, does the estray law apply in an open range county? And so because there wasn't a lawsuit here, right? No landowner had sued the sheriff or sued the neighbor or anything like that. They can't go to court, right? And there's just legally, courts can't hear cases unless there's actual controversy. So the county official asked their state representative to seek an opinion from the attorney general. And so in February of this year, the attorney general issued an opinion answering this question. Now, keep in mind, okay, this is just the opinion of the attorney general. It's not binding on a court, so we could go to court and get a different outcome. But what the attorney general thinks is that the estray law applies everywhere. And he says the county sheriff has the authority and responsibility to enforce the estray law, whether a county has adopted a local option stock law or remains open range. Okay? And the rationale for that was, nothing in the text of the statute says it's inapplicable in an open range county. The estray law was actually passed before the law that allowed counties to become closed range. And so that kind of shows an intent that it apply in open range counties, since that's kind of all there were when it was passed, right? And there's nothing about the statutes that talk about closed range counties that mention the estray law. So that's what the attorney general thinks. Will a court agree if this ever goes to a court? Who knows, right? I don't get paid enough to try and guess what a judge is going to do. I do think that there could be some factual distinctions here. So, let's say we've got a scenario in an open range county, and the neighbor built one of those sufficient fences we talk about, and the animals keep getting in. Would a court say that's different than a situation in an open range county, right, where the neighboring landowner has the obligation to fence the animals out and they didn't build a fence? Would that distinction make a difference in how the court would rule? I don't know, all right? But I think it's an interesting question, and I just want you to be aware that this opinion is out there. Okay, so that's sort of my spiel on animals getting out, animals on the roadway, etc. Louise asked, does the term livestock apply only to cows, horses, goats, donkeys, and chickens? What about ostriches? So let me look. There are a couple of different definitions of livestock. Let me see here. 142. I'm going to just pull up the estray law and see. livestock, I'm going to find you the definition here. All this says is that livestock does include exotic livestock, and it may include exotic fowl, which would be any avian species not indigenous to this state. So I don't know for sure if that includes an ostrich or not. For it to apply to exotic livestock or exotic fowl, the estray law, it only applies if the animal is tagged, branded, banded, or marked in some way that identifies the animal as being the property of the claimant. So there's that. As far as the statutes on open range and closed range, those have specific definitions within the local stock law as to what animals it applies. They would not, I don't think, apply to an ostrich just because that's not listed in the statute that allows those elections to be held. And so the open and closed range rule, I do not think applies to them. The estray law may, if they're exotic livestock and if they're marked. Okay, next topic, let's talk about the responsibility for building and maintaining fences. This may surprise you, but in Texas, there is no legal obligation for a landowner to share in boundary fence costs with a neighbor unless there's been some agreement to do so. So, for example, let's say that you go out and you buy a piece of property and you think that you need to build a boundary fence between you and the neighbor. Or you think that the boundary fence needs repaired or torn down and rebuilt. And you go to your neighbor, you knock on the door, you say, hey, will you pitch in and help me build this fence? If the neighbor says yes, you can enforce that agreement with them. But if the neighbor says no, I'm not pitching in, I'm not paying anything on that fence, you can't force them to do so. Okay, so that's something just to keep in mind. And I know that can be a big deal when you're looking at, gosh, barbed wire fences cost about, I don't know, $10,000 plus a mile to build. So I know that can be a big deal. So you can't make your neighbor pay to put in a boundary fence. If the neighbor does not share in the costs of that fence, the fence is no longer considered a common fence. It's considered the property of the builder. Okay, and that's not a huge deal necessarily, but I think it makes sense, right? So if my neighbor won't pitch in, I go spend all this money to build a fence on the boundary line. That fence is now my property, right? It's not a common fence anymore. If you build the fence inside your boundary line, so some people will not build it right on the boundary line. They'll kind of come in, a foot or so and build it on their property. In that scenario, clearly, right, that fence is the property of the builder. Do remember that you cannot enter your neighbor's property or remove trees, brush, or shrubs from his or her side of the fence in order to build a fence on the property line. That would be trespassing, so keep that in mind, okay? The other thing that I would say if you're going to look at building a fence, I would get a survey, or at least, go to the deed records and see if you can pull up a survey and make darn sure that you're building it on the right, line. Because I am here to tell you that you can really get yourself in trouble if you build a fence not on the boundary line. And again, we're looking at huge costs. You don't want that to be wrong, right? And end up with a neighbor claiming that you trespassed or trying to make you remove the fence, or those sort of issues. So keep that in mind as well. I do want to mention this statute. There is a statute here in Texas in the Agriculture Code called the Removal of Adjoining Fences Statute. I'm going to be honest with you. I've never seen a case on this. I don't know that people really use it, but it's on the books, and so I think you need to at least be aware of it. All right? What this statute says is a person may not remove a fence that is a separating or dividing fence in which the person is a joint owner absent mutual agreement. Okay, so let's say we've got a scenario where there's a boundary fence and I want to go tear it down. I cannot do that unless I get consent from my neighboring landowner if we jointly own the fence. Okay, now again, like we talked about, if I built the fence and it's my property, I can do what I want. But if it's a jointly owned fence, I can't remove it without consent from the neighbor. A second provision here says a person may not remove a fence that is attached to a fence owned in part or wholly by another without giving 6 months written notice. So let's say that we've got a boundary fence that's jointly owned and I tie into it, right? I've got a fence that's owned only by me, but it's attached to the boundary fence that's jointly owned. This says I'm supposed to give 6 months written notice before I, remove my attached fence. Again, I'm not sure that that happens in the real world, but it is a statute on the books. The last provision in this statute says a person who owns a fence wholly on her property may require the owner of a connecting fence to disconnect from that attached fence with 6 months written notice. All right, so again, if you've built a fence on your property and someone tied in, you can make them untie with 6 months written notice. Okay, that's that statute again. Just be aware that it does exist. I think this picture is funny because, right, we've got two perfectly good fences right next to each other. This sums up Texas fence law and some of the ways it can really be quite impractical, I think. The last topic that I want to touch on, and then I'm going to be glad to take your questions, deals with adverse possession and fences. So I said this before, but if you're going to build a fence, get a survey and be sure you're building it where you're trying to, because you don't want to end up in a scenario where you've got an adverse possession fight or somebody trying to make you remove a fence because you built it on their property. Okay? And this is a concern that happens sometimes if a fence is built off the boundary line on someone else's property. All right? Let me back that up. If the fence is built off the boundary line and it makes like your property be fenced under someone else's fence. In other words, if somebody else can use some of your land because of where the fence is put, they can potentially argue that adverse possession should apply, and they could go through some legal steps to try to become the owner of that land. Okay? Now, let me be clear here. It's hard to prove adverse possession in this scenario. Tough for someone to win, but it could happen, and you at least need to be kind of concerned about it. Okay? So just be aware of that issue. To prove adverse possession in this kind of situation, a person would have to prove that they adversely possess the property. So that would have to mean that they possessed it without permission, right? If you told them they can use it, it's not adverse possession. Under a claim of right, that means they have to be actually trying to claim ownership. Peaceably, that means you aren't in there trying to kick them out or you're not filing lawsuits against them. It has to be open and notorious, and there has to be a continuous use throughout the 10-year period prior to the filing. Let me give you a case. I want to talk about this. To prove adverse possession based on grazing, right? So if you've got a scenario where the fence is wrong and your neighbor is trying to say, well, that fence has been there for 40 years and we've been running cattle, and so now we own that land of yours that's under our fence. They have to actually prove that there was a designed enclosure, not merely a casual fence. And if you look at the cases on this, a designed enclosure has to actually be something that that owner did that made it clear he was claiming that land. So the fact that there was a jointly owned fence built in the wrong place probably isn't going to be enough. That's going to just be a casual fence. But if the landowner came in and, really changed that fence, so maybe they took it from a barbed wire fence to a net fence, that may be a designed enclosure. Or if they went in and built another fence on their side, letting their animals graze on your property, that may be a designed enclosure. If the fence existed before the person took possession, you've got to prove that the intent was for there to be a designed enclosure when that came into play. So again, there's some cases on this. It's a hard claim to prove, but also it's a good reason why you need to make sure your fences are built on the boundary line where you need to have them built. Okay. So with that, I'm going to give you a couple of resources. We've got about 15 minutes for questions. So I know we've got at least one here that I haven't answered or two. If you've got more questions right now, please type them in there. I'm sure more than happy to take those in these next few minutes. Okay, so I've got a blog. If you guys are interested in ag law, check it out. I'm going to put the link right here in the chat box. It's called the Texas Agriculture Law Blog. You can just click on that link right there. What it is, I just post info about ag law. So any checklists or articles, or if there's a new case that comes out, I'll write about it. You can check that out there. If you will just, when you go, a little box will pop up. If you'll put your email address there and hit submit, my post will come to you as an email automatically anytime I post something. So check that out. You can also see here there's a tab called Published Materials. Any sort of handbook or fact sheet or anything like that that I've done gets posted there. So check that out if you're interested. They're all available online for free. The next thing I'll mention is I've got a podcast. It's called Ag Law in the Field. And so if you're a podcast listener, you can find us on any of the apps where you listen to podcasts. If you're not, I'm going to put a link here in the chat box. Just click on that link. That's our website. What you're going to find is we've got about 90 episodes. It's just an interview type show where I have interviewed lawyers and different experts on ag law topics. It's audio only. You don't need video. You can play them right there on your computer for free. So if you're interested, please check that out. And then my last slide here has got all of my contact information. So if you've got questions or need more information after today, contact me by email or by phone. I'm also on social media, so if you're on Twitter or Facebook, feel free to follow me there. Okay, with that, I'm going to jump into our question box here. And again, please feel free to type any questions that you've got. And we've still got about 15 minutes or so. I'm going to even tell you if you've got questions that aren't fence law related, I'll even entertain those. So feel free to type those in if you have other ag law questions. Okay, Phil, would these laws apply to exotic wildlife like axis deer? Phil, so I'm going to, in the Texas estray code, I think that's probably what you're talking about, is the estray code. Let me pull up. I'm going to just pull that up and put a link in here. You will see in the very top there are different definitions dealing with exotic livestock. It doesn't specifically say axis. I kind of think so, but you're going to have to look at the definition and kind of chase down some other definitions that are there. So right there, Phil, is the statute. Take a look at that. If you still have questions after you look at that and look at the other statutes it refers to, let me know and I'll get you the info. Okay. Juan asks, what happens if a neighbor has a livestock exemption? Juan, I think that you typed that question when we were talking about building and maintaining fences. So that wouldn't affect anything as far as the law goes related to fences. So let's say that your neighbor has ag use valuation and he's got cattle out there. The question then, as far as who's responsible to make sure that fence is maintained, goes right back to, are we in a closed range area or an open range area? Right? If it's a closed range area and he's got cattle, then it needs to be on him, right? The law says he's the one that's got to make sure those cattle are fenced in. And so it may come into play there, but that doesn't change whether or not he has to legally, pitch in to build fences. He could be liable if he doesn't, right, from a liability standpoint, if he's got animals out there. I hope that helps. Dale, If a fence is jointly owned, can one owner cross over to clear or maintain a fence without specific authorization? Dale, I think the answer is no. If you've got a jointly owned fence, you can do whatever you need to do up to that boundary line, right up to the property line. You can't do anything on the other side. And doing that could result in claims of trespass or other type of property damage if you're, removing brush or anything. You'd want to talk to your neighbor and try to get permission to do that. Ashley says, do you have any resources regarding fences and county right-of-ways along roads? Ashley, I really don't. I just haven't worked on that. I hadn't had questions on that come up. We've certainly got a fence law handbook, and I've got a chapter on fence law in another handbook I've done, but I can tell you we don't specifically address the issue of right-of-way fences. So I don't know if this is helpful. I'm going to give you a link to this handbook that I did. You can look at that, but again, it doesn't address that issue. So I'm sorry that that's not super helpful. If you guys look at that last handbook link that I put, that's an ag law handbook I wrote for landowners. It's about 13 different chapters on kind of the key laws that you need to know. It might be helpful. There's a chapter on fence law. So you can check that out. Again, Ashley, I'm sorry, I just don't have that. Leah has a question. We built a fence on our side of the property line many years ago. New neighbor bulldozed the fence without prior consent. What is wrong with people? Now they want to pay us for part of the fence on our side of the property line. Will I still own the fence? Leah, and I have to go find the case that says it, but I feel confident if the fence is on your side of the property, you would own the fence. I mean, you may want to, in that scenario, given that they tore it down and now they're paying to help fix it, I might want something in writing that kind of lays all that out and explains that it's your fence, maybe have them sign it or something, but I sure think that that's accurate. Tina had a nice comment. Thank you, Tina. She had to leave. If you buy a piece of property with a fence, how do you determine who owned it? Good question, Bill. So kind of the default is going to be we assume that it's a jointly owned fence unless you can prove otherwise. So unless you can prove who built it, and if it's a boundary fence on that property line, we're going to kind of assume that it was jointly owned. I think that's how the court would look at it. Juan, what about old fences versus legal boundaries? I can get fired up on this one. So the rule basically is, I don't care where a fence is, that does not change the property line. There's no automatic change in property line, okay? Now, what it could do, like we talked about earlier, it could allow someone to try to make an adverse possession claim. And if they were able to succeed on that adverse possession claim, that could change the ownership of some portion of the property, okay? But there's no automatic change just because of where a fence is located. Okay, Haynes says, is the landowner in any way responsible if feral hogs or deer leave his property and are struck by a vehicle? Haynes, so long as let me back up. So long as the landowner has not done anything to try and reduce those hogs or deer to his or her possession, the answer is no. All right, so, and that's just a rule that talks about if you're a landowner, you're generally not liable for kind of quote unquote wild animals if you haven't tried to reduce them to your possession or something like that. So the answer there is no. The one caveat I'm going to give you there that makes me have a little bit of heartburn is if you're somebody who's has breeder deer where you're breeding them, you've got them pinned up, you've got ear tags or whatever in them. In that scenario, the law is not clear on that. I've never seen a case on that. I think there's at least a concern there about liability. I think they could certainly argue back and forth for a number of reasons. But short of that, if you've just got, feral hogs, wild deer, no, liability would not be an issue in that scenario. Okay, it looks like we've got a few people asking questions or typing. Will says, will this be available for replay? Yes, it will. Pete will have a link and I will post it on my website. Pete also probably can email that out. I'll let him speak to that. Oh, Haynes had a feral hog killed during the night last night. No, feral hogs, no liability because they're not owned by you, Haynes.
Yes, the link will be on here. You can go on here and you can watch other recorded webinars, and I will send you the link, Tiffany.
Great, thank you. Bob asked, am I familiar with a buffalo shooting case in King County a few years back? Care to comment? Bob, I'm not familiar with that case, so I can't comment on it at all. Sorry about that. I just not up to speed on that one. Any other questions? Guys, we've got about 5 more minutes. Like I say, we'll turn this into Q&A on any topic. If you've got other questions, shoot them to me. I'm glad to try and answer them.
I have a question that was asked
Sure.
by some hunters. Some hunters were asking they were looking to buy some land for hunting, but uh, they had that in that one place at one time had that deer chronic disease.
Oh, chronic wasting
If
disease.
it, yes, if seller's gonna sell land, does he have to disclose that was present on the land?
Oh, good question, Pete. I don't know the answer to that. Certainly, if they knew it, I think that there's a concern there. I don't know if that's something you would have to disclose or not. I'm extra paranoid, so if I were them, I probably would. But again, I'm not sure that that's legally required. If they did not have knowledge of it, I think in that scenario, certainly I don't think they would be liable for not disclosing. I don't know. I've not seen that issue come up, so I don't know the answer.